Mr. Speaker, Representative Smith moves to call on the calendar Senate Bill 172 by Senator Colomb relative to marriage, provide a minimum age of marriage, provide certain terms, conditions, procedures.
Representative Smith.
Thank you, members. And thank you, Mr. Speaker. Members, this bill looks at the minimum age for marriage in Louisiana, and currently Louisiana has no minimum age. And unfortunately, we have judges in Louisiana that have allowed girls as young as 15 to marry men as old as 35. We do need a minimum age minimum age for marriage in Louisiana, and on how large the age gap should be. So that's what this bill does. It actually allows for a minimum age of marriage by stating that a minor under the age of 16 may not contract marriage, and a minor 16 or 17 of age may not contract marriage with a person of the age of majority where there's an age difference of 4 years or greater. And that's what the bill does. And I know there are some amendments.
We have some questions, Representative Smith. Maybe let's do the amendments first. I know we have a couple of amendments, and we'll come back to the questions. The amendments, Mr. Clerk.
First set of amendments are by Representative Hilferty, 3540, 2 pages in length. They've been distributed.
Representative Hilferty on your amendment.
Thank you, Mr. Speaker. Members, what my amendment would do is raise this to the age of 17, that a minor 17 or older could contract into marriage, and not any age below that. And what this corresponds to is our age of consent in the state is 17. And so we would be saying that at 17 you can either marry or consent to sexual relations. This makes a lot of sense. This mirrors what our neighboring Texas does. And in fact, Florida just passed it to 18. So this would still put us well within range. And I think it makes a lot of sense given our consent laws in this state. The rest of it, it's 2 pages. The rest of the changes are mostly technical in nature.
For a question on the amendment, Representative Jackson.
So your amendment is saying that you would have to be 17, period, that a judge can give permission. And why didn't we move it to 18?
I would like to move it to 18. I would welcome an amendment that moved it to 18.
Yeah, I mean, do we have some people opposed to it? Because I'm a little bit concerned that I still feel like it's underage. You're still letting underage girls marry grown men. And I know you would love it, but that's my concern.
I totally respect that concern. I think the rationale behind 17 was locking it to our age of consent. And certainly anything is better than what we have now, which is no floor for marriage, which is very disappointing.
No, I totally agree, but you mentioned Florida, and I know that you're a strong advocate, and you mentioned Florida, and Florida moved it to 18 because of all the trouble they were having. I was just wondering if we had groups or something opposed to 18, why we couldn't move it to 18.
I think there's some amendments that will look to lower this age. You might look on the computer to see those amendments, but this is looking to actually raise that age.
Okay, thank you, and I thank you for your amendment. I'm just concerned that we're not at 18 yet.
I'd welcome an amendment to that effect.
Thank you.
For a question, Representative Nancy Landry.
Thank you, Mr. Speaker. What if they're pregnant? And is there an exception for allowing a judge, or is there a parent?
No.
I mean, I'm just wondering if right now, can't you get married under? Don't you have to get a judge's permission to get married?
You
at a
need
certain
parental
age?
consent as well as judicial consent. But let me say this.
So how is this different? If you
right now, you could have, and we have evidence of this this is going back to 2010, but we had a, let's see, I think it was a 15-year-old that married, let's see, yeah, thank you. I think it was close to 35 or something, so substantially older, and right now we have nothing that will stop that. I'll get you that exact age differential.
Don't you have to get judge's permission?
You do, but the fact that we have this permission being granted, I find it disturbing that a 15-year-old could marry somebody 10 plus years older than she is.
I see 15 senators voted against this, and I'm just, there are a bunch of amendments, and there are different views on what age they should be in. Do you think that maybe this is something we should send and ask the Law Institute to study to make sure we're,
Rep. Landry, I think there is. I think the fact that we've got 17 as our age of consent, we are saying that as a 17-year-old, you can consent to sexual relations, and that would, to me, correlate to the age at which you can marry. We're saying that a 15-year-old cannot legally consent to sexual relations with somebody that is older than they are. That's why we are looking at 17.
What if they're the same age? What if they're both 16?
In that instance, they can consent together to 16-year-olds, but not to marry.
Can they get married? Why couldn't two 16-year-olds get married if they had a baby?
Under this, they would have to wait until they're 17 and they could get married.
And why would we want to do that policy that would not provide for the child having the benefit of being born in a marriage? I don't see that as a good state policy. If they're both 16 years old and they can consent to sexual relations at 16 and they're about to have a baby, why wouldn't we want them to be married?
Yeah, I mean,
I know couples who are married now who got married at 16 and had successful marriages.
Certainly, we're all going to have different experiences where we've seen teenagers potentially get married, or and look, if two 40-year-olds can get married and not have a good outcome, and two 16-year-olds can get married and potentially have a good outcome, I don't think we can certainly look at. We're all going to have different experiences.
I don't think that every instances of a 16-year-old wanting to get married is a sex trafficking case.
And I'm not saying
and there
that's
are
the
cases where two 16-year-olds, just as a public policy of a state, we want children to be born into wedlock if possible, and we're discouraging that with this. It seems like if they're both 16 or 15 and they're having a baby, why wouldn't we want them to get married? Why would we prohibit it? If they want to legitimize the child after that, they would have to spend a lot of money on court costs, and as we all know, every 2 years court costs increase, and we grant the increase without any debate usually, and it could cost them a lot of money, and then they just probably won't do it. It protects the child. It's a good state policy. It protects the child. It protects the parents.
And let me say this, right now our state policy is that any child, any age can get married, which I think is ludicrous.
And that may be the case, but I thought a judge had to give permission if it was a child under 16.
They do,
and
but
so
we have instances
do we
where
not trust our judges? If we had one bad judge allow a marriage of a big age difference, and so we're going to prohibit 16-year-olds from getting married, period. It just seems like this is a Senate bill. Whatever we do right now, it could end up, that could be the law. We haven't allowed this we're putting significant amendments on it, and we haven't had the benefit of having it go through a hearing the way that it's going to be amended. And it's something that really could, drastically alter our public policy in the state, of public policy of having children born into a marriage if possible, and encouraging that.
Well, I
just feel like we should maybe have the Law Institute study this and let everybody who are experts in the area weigh in on it.
I think we can look towards our other neighboring states and see that there's a precedent that's been set for at least establishing a floor. And when we look to our neighbors, we see that floor has been set in Texas at 17 and Florida at 18. And furthermore, I would not want the 16-year-old girl in that situation to be pushed into marriage so that the actions of an older person would not
and nor would I, but I think we might be going overboard, and I can't really tell because we're putting significant amendments on, and I can't tell whether we would be with this amendment.
Representative Landry, just a minute. Representative McGee, why do you rise? I think she's asking questions, the last I heard. Representative Landry.
I'm questioning this, length of this amendment and the significance of the amendment and
This amendment is 2 pages long, and if you look through it, it frequently says it's changing 16 to 17, and that is the gist of the amendment.
But there's no way a 16-year-old can get married in this scenario. If two 16-year-olds are expecting a baby, they can't get married. There's not you're taking out the judges granting the permission.
Correct. They would wait till they're 17, and then they could get married, and then
And their parents, too? Are their parents involved in this at all?
at the age of 17, they would need judicial and parental consent to marry, but they couldn't
And they
marry.
couldn't get married at all at 16,
Correct.
even if
Rep.
Okay.
Landry, I'm just going to have to say we maybe have
Okay,
a difference
yeah,
of
thank
opinion on
you.
this. Thank you.
For a question, Representative Ivy.
Thank you, Mr. Speaker. Representative Hilferty, there's some of the presentation, some thoughts that you presented. I don't know if they're exactly accurate. And are you an attorney?
I'm not an attorney now.
Neither am I. So, two non-experts having this conversation. Right now, I know the scenario that I think everyone here agrees with is absolutely necessary to protect our children from is that 14-year-old girl and some 40-year-old male, being sold off effectively, right, to marriage. So, as Representative Landry said, this is the pendulum has been swung hard in one direction forever, and at 17 or 18, that would simply just be pulling that pendulum hard the other way with no exceptions, with no rationale or logic to scenarios that may be more appropriate, okay, but certainly not the big age gap there. So the question, right now, you gave the example that you gave. Was there judicial consent in that example that you gave, or was it just parental consent?
Right now, there is judicial consent in these examples that we've given.
I'm sorry, could you repeat it?
Judicial.
So, are we talking about the bill or current law? I was asking about current law.
Oh, current law. Yes, that's what I was.
So you're saying right now, for someone who's 14, it requires judicial consent, or
That is
does
my
it
understanding.
It may not be my understanding that it requires judicial consent. If you look in the bill, it references article it's at the very end, page 3, bottom of page 3, article 1547. It says, upon application, this is current law, not including the bill as it's drafted. Upon application by the minor, the judge may authorize the marriage when there is a compelling reason why the marriage should take place. So and if you look at the section above that, 1545, it says, an officiant may not perform a marriage ceremony in which a minor is a party unless the minor has the written consent to marry of either both of his parents, the tutor of his person, a person who has been awarded custody of the minor, or the juvenile court as provided in 1547. So under current law...
Can you reference, Rep. Ivy, where you're reading that from?
Yeah, page 3 of the bill. It actually states current law. It's got some overstriking there and adding some language. But look at the bottom of page 3. So based on my reading of this, the law only requires either parental consent or judicial consent. And so I would argue that the scenario where a 14-year-old was married off to a 40-year-old was probably not approved by a judge, but it was approved by a parent.
Okay, and what is your question, Rep. Ivy?
So the question is, you gave an example of a 14-year-old marrying off a 40-year-old. Mm-hmm. And in that scenario, you claimed it has judicial consent was required. Mm-hmm. And what I'm trying to point out, unless you know the details of that example, most likely these scenarios are not scenarios where a judge is authorizing
This is parental, you're
but
saying?
where a parent is authorizing these. Mm-hmm. And so I want to make, we're trying to solve a problem. I want to make the distinguishing factor that I seriously doubt judges are authorizing 14-year-olds and 40-year-olds.
This is the data we have, that judges have allowed girls as young as 15 to marry men as old as 35. Judges.
In Louisiana, specific cases?
Yes.
Okay. How many? Is there a number?
Does it matter? I mean, I think one's too many, Rep. Ivy, personally.
Well,
but
I'm not saying it's right. I'm just wondering how big of a problem it is. So,
here's the thing. I think we see a precedent, even in our southern peer states, of increasing this age. This is to protect our children. This is to make sure that we don't have people covering up acts of rape as a marriage. This is really a child protection issue. I can't say much more than that.
I don't disagree, and I have an amendment, and also I believe Representative Amity has an amendment as well. But next question. So 2 16-year-old kids, almost 17, right? They're pregnant. They've known each other for a long time. They've got the full support of both families, so these are stable homes with a lot of support. And the kids genuinely love each other, and they want to get married, whether it be for their for faith-based reasons or whatever. You don't think that they should be allowed to, personally?
I think at 16, they will wait however many months till their 17th birthday, and then they can go get married under this law.
So,
and I think you can use that time to figure out arrangements and whatnot, and then get married at 17.
Okay, so it's okay for them, if it's a deeply held belief, for them to have the child, delivered within a marriage. You're okay with not allowing any case whatsoever for a child to be come out in this world where they have married parents?
I can't say that I know their religious beliefs exactly and whatnot, but yes, I think it makes a lot of sense for them to wait till they're 17. That's what I'm saying. That's what this amendment does.
All right. So in the long history of humanity on this planet, right, what's been the age? I mean, culturally,
Rep.
in
Ivy,
other
we
cultures,
can look back in history and find a lot of things that we do differently now than our ancestors did, okay? So yes, I believe that 17 should be the minimum age. It matches our age of consent, and that is what this amendment does.
Okay, so about the age of consent, you mentioned it's only legal to have sex at 17 consensually. So what if you have 2 16-year-olds having sex? Are they not allowed to consent to sex at 16 legally?
Yeah, we're talking about if it's 2 15-year-olds can each consent to each other because they're the same age. 15-year-old cannot consent to a 19-year-old.
Right, but under your scenario, your example was the legal age of consent is 17.
Mm-hmm.
But so should a child be able to consent to sex below that age regardless? I mean, if they're not mature enough.
We're not talking about when, Rep. Ivy, we're not talking about, this is not to talk about when people can or cannot have sex. This is setting a minimum age for marriage in the state, which is desperately needed, and we are trying to make it this amendment is trying to make it 17.
Again, and I don't have a problem with the solution as far as it's currently stated, barring a couple of minor changes. But do you disagree that the pendulum is swung hard one way and you're trying to swing it back fully the other way without any possible exception to the scenario?
If you could hold it down, members, we're having a hard time hearing the questions and the answers, please. Go ahead, Representative Ivy.
Yes, ma'am. So again, do you agree that the pendulum has been swung far one way and that your amendment just brings it fully the other way?
The pendulum was that there was no minimum age, which in our state, this is setting the minimum age in this amendment to 17. That's all I can say about it. It's a very simple amendment.
All right. Thank you.
For question on the amendment, Representative Jackson. She waves. For question on the amendment, Representative Hodges.
Thank you, Mr. Speaker. Basically, I just had the same question, I think, as Representative Ivy did. But I just want to be clear, because I think there's a little confusion over here, that if a young girl, let's say she's 16 and she's living with her boyfriend, they're in love, and she gets pregnant. Even though they want to get pregnant, they want to get married, and her parents say yes, if this passes, a judge couldn't grant them the right to get married?
16-year-olds? I'm sorry, I can't hear. You're saying 16-year-olds?
Yes.
Correct. This is setting it at 17.
But there's a lot of that happens, okay? And so
There's a what? I'm sorry.
There are cases of that a lot of 16-year-olds get pregnant, unfortunately. And do you feel like it's better for them not to get married at all and for that child to be born illegitimately, or to have to marry that person? That's my concern.
With this amendment? Not in this amendment. With the amendment? Okay. I'm being told that if they're both the same age, under this bill with this amendment, they could still get married. No?
But what if
No.
in that
Okay.
in that scenario?
I'm sorry. Sorry, Rep. Jackson. Look, no. What this is saying is 17 is the floor. That's it. With all due respect to the body, I think the amendment speaks for itself. I'd like to end questions.
Okay, thank you.
There are no other questions on the amendment. For the floor on the amendment, Representative Stefanski.
Members, I think this is a good amendment. I think this is, I would prefer it be 18, but I think this is a good amendment. Nobody's saying two 16-year-olds can't be together. Nobody's saying you can't stay together. But you know what also is expensive? Not getting married and having to go to court and having to get the child filiated, which Representative Landry was talking about. It's also very expensive to get a divorce when it doesn't work out too. So I would encourage you to support this amendment. I think it's a great amendment. Thank you.
For the floor on the amendment, Representative Smith.
Members, I've heard a lot of conversation about this, and I do support this amendment. You talk about a 15 or a 16 or even a 13-year-old getting pregnant. I brought that up last week. And I also brought up the fact that you don't want to teach sex ed in Louisiana. So you want to do nothing preventive, but what you want to allow is a rapist, a 45-year-old, a 35-year-old to marry a 15-year-old. That's rape. That's actually rape. It has nothing to do with anything else but rape. And that's being allowed in this state. Those individuals are allowed to get married by judges. And we've had, by record, folks, we've had a marriage of a 40 to 44-year-old with a 15 to 17-year-old, 3 30 to 34-year-olds in the state of Louisiana. Under 16-year-olds, we've had 32 18 or 19-year-olds marry 30 to 34-year-olds. That is not right in this state. We need to have and protect our children. We need to protect them from all of the things that we know. And I can tell you, as a Catholic, if you get pregnant, you go to the priest and you ask him to marry you. The priest will, if he decides that marriage is only because of the pregnancy, then they can postpone that wedding until you are of age to marry. So it's different in different religions. I realize that, but I do know in the Catholic religion it's not allowed. So I support this amendment.
For the floor on the amendment, Representative Ivey. Members, we have 3 more amendments on the bill, so please be brief. We got 3 more to talk about. For the floor, Representative Ivey.
Members, to be clear, I support the bill to address the problem. The example Representative Smith gave about the large age gap, this bill in its current posture addresses it. There is a 2-year age gap limit in the bill in its current posture. This amendment, I believe, actually strips it out, if I'm not mistaken, and just makes it 17 years period. So the bill does limit the age gap, and the bill in its current posture does allow for a 16 or 17-year-old to get married with parental consent. So this isn't going. In that scenario, it means they could only marry someone who is either 18 or 19 years old at the oldest. And so again, I believe the bill in its current posture takes care of most of the concerns that people naturally have in this. So I believe this amendment, it strips all those other scenarios and really creates a very narrow option. Thank you.
For the floor on the
Please
amendment,
oppose it.
Representative Amity.
Thank you, Mr. Speaker. Members, I rise in opposition to the amendment. I met my husband when I was 14 and he was 15, and if it wasn't for the belief that we should actually get a high school diploma before we get a marriage license, we would have been married when I was 15, and our parents would have allowed it. Remember that sometimes young people, in the situations that they have to deal with in their own home life, emancipation happens when you're married, and you can sometimes set out on your own and do better and have a better life because of what you're walking away from. I would not prefer to limit that just by saying arbitrarily that no one can get married under the age of 17, period, no ifs, ands, or buts. So I ask your opposition to this amendment.
There are no other members for the amendment. Someone objected to the amendment at some point. I think I've lost track to whoever objected. Representative Amity, to which Representative Amity objected. Representative Hilferty, to close on your amendment.
Members, I appreciate everyone's comments and thoughts on this amendment. It's very simple. We're saying in the state of Louisiana, you must be 17 to be married. This will certainly protect our children. This will allow potentially acts of, and I'm not saying this is in every situation, but an act of rape to not be covered up with marriage. And furthermore, and most importantly, our age of consent in this state is 17, and that is what we are setting as the minimum age for marriage. I'd ask for your favorable passage.
Representative Hilferty offers an amendment to which Representative Amity has objected. When the clerk opens the machines, those in favor of the amendment vote yes. Those opposed vote no. The clerk will open the machine. Vote your machines, members. Representative Abraham, no. Representative Talbot, yes. Representative Henry, yes. Are you through voting? Are you through voting? Representative J. Morris, yes. Are you through voting? Clerk will close the machine. 63 yeas, 31 nays, and the amendment is adopted. Next amendment, Mr. Clerk.
Is by Representative Amity. It is 3602 and 3 pages in length and has been distributed.
Representative Amity, on your amendment.
Members, I'd like to present this amendment. Now that we have changed the actual age on the bill, we'll have to adjust this amendment, so we may have to go back in the room and come back with the amendment in a moment, but let me tell you what the rest of the amendment does. I'm sorry? Okay, yeah. What this amendment will do is it will require that the let me see. It would require that an underage, a minor who would want to get married would have to go before a judge, and the judge would have a lengthy list of questions to ask, and this is what would protect us from having people marry because of human trafficking. The middle part of this amendment requires the clerk of court to send a copy of the application of a marriage license, an application for a marriage license that contains minors to the Registrar of Vital Records, and it will be reported annually to the legislature. This would also require that when a judge does this interview, if he finds evidence of abuse, rape, human trafficking, or any of those things, he would have to call the sheriff or Child Protective Services. But in the bill's current posture, this amendment will have to be adjusted. So, Mr. Speaker, what is the process for tabling the amendment for a moment while we redraft? Okay. I will withdraw the amendment at this time. Thank you.
Lady withdraws the amendment. The next amendment, Mr. Clerk.
The next amendment is by Representative Ivy, 3600. 2 pages has been distributed.
Representative Ivy on your amendment.
Thank you, Mr. Speaker. Members, let me explain the reasons I brought the amendment in the first place. This is, of course, before Representative Hilfredy brought her amendment. So if you look on page 2, line 18, it says it deals with the emancipation. As I read this and understand this, we require an emancipated minor that is 16 or 17 in the bill as it currently is postured, well, with the exception of the amendment that was previously adopted, it would require an emancipated minor at 16 or 17 to get their parental consent. Well, that could be problematic, getting parental consent if you are already emancipated. So one of the issues I wanted to do is require that the minor that is 16 or 17 get either parental consent or judicial consent. So the oversight is still there, the protection of the minor is still there in the scenario, but this would allow for a situation where if you had a child who was estranged from their parents and it was a bad, difficult situation, which may be why they may be emancipated, it would allow them to go before a judge to get that consent in there for an emancipation. So it brings back the emancipated component. The other component that the amendments add, we keep the 2-year age limit difference, we keep that, but understanding that there may be scenarios in life that would make something not so unreasonable where two 15-year-olds were to get married, or a 15-year-old and a 17-year-old getting married with proper parental support, and usually these situations would be centered around a child being born. And so this would allow the exception, which is currently not allowed in the bill and certainly not under the amendments that were adopted. But in order for anyone under the age of 16 to be married, okay, it would require parental and judicial consent. So the checks and balances would be in place where a judge would, if they felt it necessary to have the support of both parents of each child there, and the financial support and everything that would be necessary to make it a more potentially successful endeavor, then the judge has that. It absolutely, I believe, protects from these crazy scenarios that have been discussed where you have a 13-year-old and a 40-year-old. So that's what this amendment does, members. One moment. All right, members. So please pay attention to the motion I'm about to make. I'm going to ask for your consideration that we adopt these amendments. If my set of amendments gets adopted, the next motion I will make is that we reconsider the vote by which the previous set of amendments were adopted and have those removed, because obviously both of these cannot exist at the same time. And without having to go get a set of amendments drawn up that removes these effectively, that's what needs to happen under any scenario. So if you prefer my colleague Representative Amity's amendments over mine, well then you're more than welcome to vote mine down and support hers and have the others removed, because obviously these amendment sets can't coexist. So with that, Mr. Speaker, I'd ask that I move for the adoption of these amendments.
There are no questions on the amendment. Representative James, did you want the floor on the amendment? Representative James.
Mr. Speaker, I move that we end consideration of amendments.
Okay, we'll still have to. We have two remaining amendments after we finish Representative Ivy's. Representative Amity and Representative Jackson have two outstanding amendments. The motion has been made to end consideration of amendments. Is there any objection? Representative Ivy objects. When the clerk opens the machine, all those in favor of ending consideration of amendments vote yes. Those opposed vote no. The clerk will open the machine. Representative Abraham, no. Representative J. Morris, no. Representative Lacombe, no. Representative Chad Brown, no. Representative White, no. Representative Talbot, no. Representative McGee, yes. Representative Amity, no. Are you through voting? Clerk will close the machine. 24 yeas, 69 nays, and the motion fails. Representative Ivy has offered an amendment. Is there any objection to the adoption of his amendment? Representative Smith, on your objection.
Members, I spoke with the author of the bill. She was in favor of what I felt was right with the bill and also the 17-year-olds amendment that was put on. So I am asking you to vote against this amendment.
Representative Ivy, to close on your amendment.
All right, members. Before I had the amendments drafted, I did speak with Senator Colomb on this, and in concept, she did not. She agreed with the amendment set, and I do believe that Senator Colomb is trying to solve a problem and is probably favorable to any one of these sets of amendments. So, just because she was in favor of the other one does not mean she's not in favor of this one. And without her clarifying which one she may prefer, I wouldn't assume either. That said, doing nothing, I believe, is a problem. We do need to address the scenarios that have been discussed. And so I do believe that we do need to pass something. Some have suggested that we study the issue, which we should. But I believe that a more middle-of-the-road balanced approach today with additional study, we can possibly come back and tweak it. But if we go full tilt the other way, we leave no remedy for practical exceptions that we just haven't discussed. And so I do believe it would be more prudent to in the first change in a century to try to land somewhere in the balance and not in some far extreme. The bill in its posture before the first set of amendments were added, coupled with my set of amendments, does offer the protections. The 2-year age gap is still there. Any exception to under the age of 16 or the age gap requires parental and judicial consent. I also provide a remedy for the emancipated minor not having to only be able to go to their parents for the exception. It allows for a judicial consent if they're already emancipated. So it was my understanding that there were 15 senators who opposed the bill as it left in its posture from the Senate. I do believe we need to do something. I believe if we overreach on that, I believe that it's a high likelihood the bill will just fail, and then there's no remedy whatsoever. So, members, I do ask for your favorable adoption of this set of amendments so I can then offer to strip the previously set of adopted amendments. Thank you.
Representative Ivy, you have a question. Will you accept a question?
I'll take a question.
Representative Stokes for a question.
Thank you, Speaker. Did you know that probably full tilt would be the age of 18
Right.
to not be able to
One
marry,
whole
and there
year
wouldn't be
difference.
any judicial, wouldn't be any judicial remedy, which there is. But couldn't the church marry someone, but not with the express, they're not legally married in the eyes of the state?
In the bill, it doesn't allow.
This is a separation to me of
No,
church
you
and state,
can't. In
too.
the bill on page 3, it has a section talking about marriage ceremony, and it actually prohibits the marriage ceremony from being able to take place.
All right, thanks.
Representative Ivy has offered an amendment to which Representative Smith has objected. When the clerk opens the machines, all those in favor of the amendment vote yes. Those opposed vote no. The clerk will open the machine. Vote your machines, members. Representative Smith, no. Representative Talbot, no. Representative Leger, no. Representative White, no. Representative Gwynn, no. Representative Henry, no. Representative Abramson, yes. Are you through voting? Clerk will close the machine. 22 yeas, 73 nays. The amendment fails to pass. Next amendment, Mr. Clerk.
Representative Jackson.
No, the staff withdrew it.
Next amendment, Mr. Clerk.
Is by Representative Amity, 3623, 3 pages in length, and they have been distributed.
Representative Amity on your amendment.
Thank you, Mr. Speaker. Members, what my amendment would do is to withdraw the previous amendment by Representative Hilferty, and going back to the original bill, what it would do is it would return the possibility of marriage to those 16 or 17 with parental consent only, and it would allow the possibility of marriage under that age with a very thorough judicial review and the consent of both parents. It would require the clerk of courts to send the application for marriage of minors to the Registrar of Vital Records, which would also end up returning to us here in the House in the form of a report annually. It would require that the court considers the best interest of the minor concerning a prospective spouse. It has a lengthy list of questions to screen for human trafficking, abuse, sexual assault, and so on. And should any be found, it requires that the judge would report that to the sheriff or DCFS, Child Protective Services. This amendment has the support of Louisiana Southern Baptist Association, Louisiana Family Forum, and I spoke with the gentleman who sent out an email previously about human trafficking, and he said that he would not oppose this amendment because he loves the lengthy list that the judge would be required to review with the prospective couple. I feel that this does allow for marriage in certain circumstances, such as you've heard so far this evening. For example, when there is an underage person, but they're expecting a baby already, and we still want to encourage that babies be born in wedlock. It also will help prevent abortion, because in many cases, when a young lady ends up pregnant, if she is not married or cannot get married, Dad brings her on down to the abortion clinic because he's not going to have any of that. So I believe that this amendment goes a long way to preventing what we're trying to prevent: abuse of minors, human trafficking. I believe that it also still allows a marriage ceremony to be performed in the case where there are minors involved, where marriage is preferred, especially by the family, and especially in regards to many of the church teachings. So I ask your favorable passage of this amendment. Thank you.
For a question on the amendment, Representative McGee.
Thank you, Mr. Speaker. So, Representative Amity, if I understand your amendment correctly, you're saying that the judge would be the appropriate person to make this determination.
Well, with the parents consenting, the judge would have final say.
And you think the judge is a good person to make that decision?
They should be, or else they should be impeached.
So you think that this would not be an appropriate question for a jury, that a judge would be the best person to handle that because they're qualified?
I don't believe this would send the couple before a jury. It's a judicial review. The judge would ask the questions and make a report.
So you think that the judge is capable of making this decision, but how would you feel about them deciding a $35,000 car wreck?
if they are a good judge, I don't have a problem with that. That's what they do, isn't it?
Oh, thank you.
For a question, Representative Nancy Landry.
Thank you, Mr. Speaker. Representative Amade, did you know that marriage brings benefits with it, not just social benefits, but also legal benefits that protect both spouses and protect the child that's born in the marriage?
Yes, ma'am, and that's why I feel this is so important. I feel that we can't just belittle the state of matrimony. It has its benefits.
And did you know that one of the benefits of marriage is that the parties that get married are automatically emancipated if they're minors when they get married?
Yes, ma'am.
And emancipation means that they're treated as adults in the eyes of the law. Did you know that?
Yes, ma'am.
And so when you're raising a child together and you're not emancipated, you're still under the authority of your parents. And being a family law lawyer, did you know that there are a lot of parents who interfere in the raising of their grandchildren? And sometimes it's wanted and sometimes it's beneficial, but sometimes it's interfering and it causes conflict in the relationship of everybody. And if you don't allow people to get emancipated by marriage or any other way, or require them to spend significant amounts of money to get emancipated by having to hire a lawyer and go to court and file a petition, that there's going to be more conflict in these relationships because the parents won't have the full authority that married parents have when they when they're raising a child. Did you know that?
Yes, ma'am, I do agree.
And did you know that marriage secures the rights of the parents and protects the child? And it's always been a public policy of this state to encourage policies that promote children being born into marriages.
Yes, ma'am.
And did you know that most marriages between 16-year-olds who are close in age, teenagers, are people who are in love and are having a baby, and they're not victims of sexual trafficking. They're two people who are in love, who are expecting a baby and want to get married. And this bill would actually, in the form that it's in before your amendment, would actually prevent that from happening now. Did you know?
Yes, ma'am, that's been my observation also.
I think your amendment is good. Thank you.
Thank you, ma'am.
There are no other questions on the amendment. Is there any objection to the adoption of the amendment? Representative Smith, on your objection.
Members, I'm standing here in awe. The irony of it is that I keep hearing the objection to this bill and the age is a person getting pregnant and getting married. And yet, this body has chosen forever and a day to do nothing about prevention and education. Absolutely nothing. You do not want to teach sex education in your schools, but you want to say that a person gets pregnant. You want to keep talking about pregnancy. I don't understand that. I truly don't understand that it doesn't compute to me. So I'm objecting to this because this is a good bill to raise the age to 17, leave it at that, and I'm not going to agree with the amendment. I just wish you all would think about what you're really voting on sometimes when you vote on it. Thank you.
Representative Amity, to close on your amendment.
Thank you, Mr. Speaker. Members, for the reasons that we've discussed, marriage is still a valid and valuable institution. This amendment is supported by the Southern Baptist, by Louisiana Family Forum, by the author of the bill. I urge your passage of this amendment.
Representative Amity has offered an amendment to which Representative Smith has objected. When the clerk opens the machines, all those in favor of the amendment vote yes. Those opposed vote no. The clerk will open the machine. Vote your machines. Representative Bacala, yes. Representative White, no. Representative Davis, no. Representative Greg Miller, no. Representative Jordan, no. Are you through voting? Representative Abramson, no. Are you through voting? Are you through voting? Clerk will close the machine. 54 yeas, 39 nays, and the amendment is adopted. Next amendment, Mr. Clerk. There are no other amendments. For a question on the bill, Representative Jackson. She waves. Representative Jackson, do you want the floor on the bill? She waves. For the floor on the bill, Representative Nancy Landry.
Thank you, Mr. Speaker. I'm not even really sure what the bill does now because it's been amended, and I think it's better now than it was, but we debated this bill in a way that made it sound like marriage is a bad thing. And it was really disturbing to me because a lot of 16-year-olds are very mature, and we're lumping them all into one group and acting like every 16-year-old that gets married in this state is a victim of sexual trafficking, and that's just not the case. I mean, there may be instances of sexual trafficking, but most 16-year-olds who are getting married in Louisiana are getting married because they're expecting a baby and they're in love and they want to get married and their families want them to get married. When you're married and you have a baby, there's no issue of paternity. You don't have to go to the court and prove paternity. You don't have to take a DNA test. You don't have to sue for child support. Marriage secures rights for the couple too. It provides, in Louisiana is a community property state. Your property is protected, and in the event of divorce, you share that property equally. You have a vested right in that property that you acquired during your marriage. It protects women, and community property states historically protect women's rights better than other states. It gives you health insurance benefits from your spouse if your spouse gets health insurance benefits at their work. It has tax consequences. So you can file married filing jointly instead of filing singly. You get Social Security benefits, both to the spouses and to the children, without having to file anything about paternity, without having to spend legal fees, filiating your child, which most couples would have no idea that they even have the need to do that. It has benefits with legal decision making for health decisions, both for the child and for the spouses to each other. It has inheritance benefits. There are many benefits legally and socially to marriage. And when two 16-year-olds have had consensual sexual relationships that resulted in a baby being born, we shouldn't prohibit them from getting married and allowing them to become a family and mature and step up and mature and grow up and raise the child in a married family. There are lots of benefits to it. It's not all instances of an older person marrying a younger person or sexual trafficking. It's happened for decades in Louisiana, and we've always had marriage and babies born in marriage as a public policy in the state, and I would hate to see us with this confusing bill do away with that. So I just want you to think about that. I mean, marriage is not a bad thing. It is a good thing, particularly when you're about to have a baby. And so we just need to be careful what we're doing here. And my suggestion is that we would send this to the Law Institute and let them study it and have a much better discussion about it in a committee than to hurriedly pass a bill that we don't even really know what's in it or what public policy we're advancing with this bill. So I would urge you to vote against this bill. Thank you.
For the floor on the bill, Representative Amity.
Members, I didn't like this bill when I first saw it, but with the amendment on it, with the amendment that I put on it, it actually leaves our marriage laws with the age arrangements as they currently are in law, which would mean that an 18-year-old can get married without anybody's permission. A 16 or 17-year-old would need mom and dad to agree and sign the marriage license application for them. And someone under 16 would have to have mom, dad, and the judge agree. And it will require the judge to go through this lengthy interview process to identify if there is any abuse or human trafficking going on, and report it if he finds it. So in that way, I think it actually improves our laws if what you're concerned about is abuse and human trafficking. So I would urge you to support the bill. Thank you.
For the floor on the bill, Representative Hilferty.
Thank you, Mr. Speaker. Members, I appreciate everyone's comments. Several of us feel very passionate about this issue. Well, I don't agree with Representative Amity's amendment because it does not, let me repeat and be very clear, it does not set a floor for marriage, okay? Which puts us in a similar stance to where we are now, but it does provide a good degree of qualifications that the judge would consider. I would encourage you to support this bill so that we may send it into conference with hopes of cleaning this up. I think it is so imperative that we as a state have a limit on age for marriage, or I'm sorry, a floor on age for marriage. Our peer states have this. Right now we have none. With this amendment, we would still not have one, but it would require the judge to consider some qualifications before allowing two individuals to marry. Again, let me repeat, I ask you to join me in voting for this amendment so we may send it to conference committee. Thank you.
There are no other members for the floor. Representative Smith, you have a right to close.
Members, I'm just going to say I agree with Representative Hilferty and ask you to support the bill.
Representative Smith moves final passage of the bills. Many in favor of final passage vote yes. Those opposed vote no. The clerk will open the machine. Vote your machines, members. Are you through voting? Representative Smith, Representative Jackson, yes. Representative McMahon, yes. Representative Henry, yes. Are you through voting? Are you through voting? Clerk will close the machine. 66 yeas, 28 nays. The bill's finally passed. Representative Smith moves to reconsider the vote. The bill finally passed. Lay that motion on the table. Without objection, so ordered.